Okay, thank you everyone for coming today, as we're pleased to present Christine Kearns. Ms. Kearns is a graduate of Duke University and Vanderbilt Law School, and has spent her career in big law, working for over 20 years at Pillsbury Winthrop's DC office, where she specializes in employment law and litigation. Ms. Kearns has argued numerous state and federal cases, including in front of the Second and Fourth Circuits, as well as the DC and Maryland Courts of Appeals. Named by the Washingtonian as among the best lawyers in her field, Ms. Kearns has served as the chair of Pillsbury's hiring committee, as well as sitting on their board. Earlier this year, Ms. Kearns was named managing partner of the DC office, where she heads an office of over 200 attorneys. Considering Ms. Kearns has had such a successful career, all the while raising a family of 4 children, there is no surprise why Wilsa is honored to welcome her to speak today.
Thank you, Kate.
Thank you.
Well, good afternoon. I'm so happy to be here. And I was told I had 45 minutes. I thought I would devote 44 of them to talking about wonderful and interesting things you don't know about my daughter, Elizabeth. But then I concluded 44 minutes wouldn't be enough to talk about wonderful things about Elizabeth, so we'll save that for another time. Maybe we'll save that for the questions and the answers. I'm delighted to be here, and I thought I would start with a true story. Kate mentioned I went to Vanderbilt Law School, and the very first day at Vanderbilt Law School, we had orientation, and the dean of the law school addressed the class, and he pointed out what a great entering class Vanderbilt had and said, you know, what great GPAs coming from your undergrads, what terrific undergrads, what LSAT scores, what interesting extracurricular activities, what a fine group. He said, indeed, this might be the finest group of first-year law students ever rejected by Duke Law School. That's a true story. But anyway, so I loved Vanderbilt, and I thought it was a great experience. And I did go immediately to work in a big law firm from law school. And like Elizabeth, I took a little bit of time off before I went to law school. So I started at the law firm when I was 28 years old. And I've been there ever since. And I started in a class, I think there was an entering class of 12 first years at the school, in my law firm class. And I think 8 of them came from Harvard Law School. So I was immediately very intimidated. But I, tried my best. And as time passed, I was in the litigation group, and about 5 years in, I decided I wanted to have an area of specialty, which is something I would recommend if you're going to go into litigation, and I gravitated towards employment law. I hadn't taken any classes in employment law at Vanderbilt, but I learned on the job, and frankly, in the years I've practiced law, some of the major statutes have been passed, and employment law has really evolved, and so I began representing companies in all kinds of employment disputes, and I have handled at both the trial level and the appellate level, everything from the most outrageous sexual harassment, age discrimination, family and medical leave, breach of contract, stealing trade secrets, pretty much anything that goes on in the workplace, I will handle for our clients. And as I'll say, matured, I do a lot of counseling. So rather than hiring me when things go wrong, people hire me to ensure that things go right in the workplace. So I'll do training, or I'll help them sort of establish their infrastructure so they have all the right forms and follow all the right protocols when they hire and fire, so they ask the right questions in an interview. And so I would say I spend about a third of my time now counseling. But my real love is really the litigation and, frankly, winning. And I've had some great good fortune to win some really fun and interesting cases. And I've had some really unusual cases, which happens in the employment context. And I thought I'd just give you 2 examples of things that are so bizarre it's hard to believe they're true. This is true. I had the pleasure, when I was a young lawyer, of representing the Daughters of the American Revolution. And I don't know how many of you are members or have mothers or grandmothers who are members, but they're an older profile is involved with the DAR, and they fired their librarian, and she was 78, and she sued for age discrimination because she was replaced with someone who was 68, and that was luckily like shooting fish in a barrel. I was able to demonstrate that they were not ageist at the DAR. A somewhat trite example, but things come up in the workplace that are very, very interesting and very funny. And that's for a whole nother conversation, perhaps. I don't know how many of you are interested in that area. But I wanted to talk about, three things that sort of come to my mind as I give advice, if you will, about entering the workplace as a lawyer. When I entered the workplace as a lawyer, picture this, there were no computers anywhere on lawyers' desks. I mean, secretaries had a computer for word processing, but no one had a computer on their desk in 1987 in big law firms. There was no voicemail. Your secretary took your calls, and at that time I was Miss Nicolaides, Christine Nicolaides' office, and she would write a note on a piece of paper, and you would tape the piece of paper, and you'd create a whole pile of pieces of paper. In fact, there's something that's now an antique that's a pointed thing where people kept all their messages. There were terminals in the library for Lexis and Westlaw, but there was, and this was a very large law firm in Washington, there were 2 terminals, which people, there was never a backup to use them, because what you did is you went to the books and went to the digests, and then you literally took a crate, a cart, through the library and collected the books, carted them to the copy center, where overnight they would copy the pages of the cases, and then the next day you would sit down with them with your highlighter. It was we knew nothing different, but it's so much different now. And that's how we started out learning. The library was a center of really all young lawyers' work efforts. One was never in her or his office, and also somewhat the social center too. And I noticed that with the associates who work with me now, no one ever goes to the library. People call the library, and the library assists them, and we're very lucky to have the library on our floor. But everyone really is a slave to their computer. And while I think there's some enormous benefits to that in terms of research and efficiency, there is a lack of interaction among attorneys talking about issues that I think has been lost as everyone turns to their computers for research. And anyone who's ever worked for me knows that I have a little bit of a pet peeve about young associates immediately jumping on Lexis and Westlaw, because I sometimes think if you open the digest and open the books, you actually learn things and see the context of the research you're doing, and actually find things that you don't always find just by doing word searches, no matter how careful and smart you are at word searches. But among the things that really struck that I wanted to tell you about, aside from the lack of technology and the research differences then, is that there were no women in the litigation group. No women partners. None. There were quite a few women associates, but there wasn't a single woman, just to make sure, I don't want to overstate this. There was not a single woman when I started who was older than I was in the litigation practice in my very large Washington law firm. I had taken a couple years off, so there might have been people a year or two ahead of me in law school who were second and third years, but no one was older than I was. And in the law firm, there were women partners, but there were very few, and they were in other practice groups. Really impressive women, but I spent the vast majority of my professional development as an associate, well, my entire development as an associate, without any women to model. And so I'm very conscious now of the fact that I have so many women who work with me. In fact, I hate to say this to the men in the room, again, I don't want to overstate it, I think everybody who works with me is a woman now. They're all, I think of them as young women, but they're all ages, in their late 20s, early 30s. I think one is 40. And I don't do that out of exclusivity, honestly. I do it because I think that there might be something about they might be attracted to my practice area or to me, and it just has worked that way. And I've got 5 or 6 or 7 women who are just really terrific working with me. But you might wonder, well, that must have been hard or weird. Of course, I didn't know any different. And so what I wanted to offer to you out of my lesson there is you'll be surprised where you find your mentors. You'll be surprised at the people who give you a break, open the door to you, or a role model to you. And I would love to check in with all of you in about 5 years, and I bet you will say it's going to be someone you would have never guessed, someone you never would have thought you would relate to in any way, who gave you a chance, who saw something in you. And so I just really want you to be open and keep your eyes open. There are mentors, or even if they're not formal, there are people who can teach you everywhere. Just watch them. And even though we're talking mostly about the professional thing, I will tell you that there were 2 partners in the litigation group, Mr. Cinnamon and Mr. McKay, who Elizabeth knows, and they were quite a bit older than I am, but they left every day, and they're very successful, but they left every day at 6 o'clock to have dinner with their children, every day. Now, they both had the benefit of a wife at home and everything, and they would work afterwards, but I saw that as what one did, and a way you could actually be successful, and in my eyes, they were hugely successful, but a small thing they did is they role modeled sort of the work-life family, and it was men who showed that to me, not women, because there, as I said, there are no women. So I just offer to you that keep your eyes open, because some of the best chances I had were from people who I would never have thought would have given me a chance. This is, again, a true story. I was in London to take the deposition, or to defend the deposition of the CEO and the CFO of a global asset management company in an age discrimination case where they had fired a very senior woman in New York, and she had sued both the New York branch of this company as well as their UK parent and some of the UK executives. And there are interesting issues about the extraterritorial effect of the age discrimination statute. But I went over there to defend the depositions of these titans of the industry, and I was sitting, and they had put me up at the Carlisle Hotel, which is quite fancy. And I remember thinking, I can't imagine how I got here. Here I am defending the depositions of these people who pretty much have their pick of lawyers in the world. And I think I'm doing a good job, and it's going well. And I'm sitting in the Carlisle, practically eating bonbons at night. And I picked up the phone and called this partner in the corporate group of the law firm, and I left him a message, and I said, I wasn't quite as silly as I've been with you about it, but I said, here I am, the depositions are going well, but I just want to thank you. So the companion piece to keeping your eyes open for the people who are going to give you a chance is, give them a little shout out every once in a while, because I think most of the time they know what they're doing when they give you a break, and it's nice to be acknowledged. The second thing I was going to talk about is, again, sounds a little perhaps overly feminine, but you'll understand it, I think, which is bloom like a flower wherever you are. What do I mean by that? I mean that particularly in this economy, many of you, I would suggest, are going to end up in jobs that are not your first choice coming out of law school, or getting assignments that are not your first choice, or gosh, you could even be in a city that's not your first choice. And even if you leave here and you have your dream job, you think when you leave, there are going to be aspects of it that are not appealing to you. For example, getting an assignment that you don't like, or being asked to work for a partner who's particularly difficult or unreasonable, because there are plenty of those out there, and I've been accused of it myself. So when I say bloom like a flower, is wherever you are, try to make the best of it. I'm not saying be a Pollyanna, except there's going to be something good and valuable about anything that ever happens in your professional career. And if you, rather than put your head down and say, oh, I'm stuck in this dreary job and it's not what I wanted, all my friends are in a big firm, or all my friends are clerking for judges, or whatever you wanted and you may not have gotten, wherever you are at that moment, you make that the best place for you. And I promise you, you'll be so much happier, you'll do better work, and people will receive you better. So while it sounds corny, at those moments where you're like, I hate this, that's when you really have to go with bloom like a flower wherever you are. And I really mean it, because I would never, there are plenty of times along my path that I found it a little either overwhelming, or I didn't like what I was doing, and I was discouraged in the workplace. I thought I had been treated unfairly. And although I only came up with this expression somewhat recently, I tried to live it a little bit that way. and be optimistic about it. And, you know, as I said, I arrived there when there were no women to look up to, and as Kate mentioned, they made me the chairman of the recruiting committee. Then they made me the chairman of the partner compensation committee, which sets the pay for the partners. I mean, that's a really sensitive job. Then I was elected to the board, and now they've made me the managing partner of this big office. And I have to think it's more about the what I'm conveying than even what Duke Law School rejected years ago. You know, but seriously, I think that there's something about your presentation and your optimism that's got to be a companion piece to your success when you know, like as I said, when you like to win cases. That's my second piece of advice or suggestion. And third, I was thinking about the fact that probably many of you are late 20s, maybe early 30s, but 20s, going up to 30. And I say this as a much older person. The next 10 years of your life, I think without a question, will be the most action-packed probably of your life. Because in those 10 years, you will start your professional career, which is huge. Many of you will find a life partner, get married, and probably even have children or not, move to a new city. Huge professional and personal, I don't want to say tumult in a pejorative sense, but major changes lying ahead. And you sit here with those 10 years ahead of you with no clue, like what, 5 years from now, who's going to be sitting on your lap, who's going to be sitting with you at dinner, it's such an amazing thing to be at this juncture. I mean, I look out at my age and I can kind of see my people, you know? I know my people, but it's so exciting. But it's so overwhelming. And, you know, books have been written, I'm sure. But what I would offer you as you do that is, A, it's so cool to be in that spot. But the only thing that's really important is loving your family and taking care of yourself. Because at the end of the day, no matter what great job you have and no matter how many committees they put you on, you really only have yourself and your life and your family. So I would say that, you know, obviously do your best. I hope you think about the advice I gave about blooming like a flower, but just kind of be true to yourself as you get out there into the workplace. Now, I thought I would then turn from my advice, my lawyerly advice, to talk a little bit about some important changes, if you will indulge me, in employment law, because so many of them will affect you guys. And I wanted to talk briefly about a very important case that the Supreme Court is going to hear, the Quan decision. I don't know if you're familiar with that. In the employment practice, we're always telling employers they have to have a handbook. And in the handbook, among other policies you have to have is what we would call the internet use policy. So basically you tell your employees, and even law firm employees, if you go on the firm network, it's all ours. It's open and available to us. It's ours. Do not consider it personal. In fact, don't use it for personal things. And how many people follow? Very few people follow that. I mean, all of my emails, personal and professional, come from pillsburylaw.com. But people know what's called an expectation of privacy in the workplace's network system. And that's just been the law forever. And that's the advice we give, which is put it in writing in your handbook, and then no one can be surprised if you go in and take a look. Well, in the Ninth Circuit, in the Quan decision, found that a police department in California went into the pager of a police officer and fired him for things that they found there. And he sued, saying that they shouldn't have done that, even though it was a work pager. And he argued that that they had told him orally that he could pay for any overages on the pager, and so he did have an expectation of privacy. And completely going against sort of settled practical and legal advice, the Ninth Circuit said he was right. And the employer had no right to go into their own paging system and check out his text messages. And because that sounds sort of like a small point, but the Supreme Court has taken this up because there's such a controversy over who's got the right of privacy, the employee or the employer. And so that's a really important case that we're watching in the employment practice at this time. And privacy in the workplace is something that is really going to be a hot area as you guys enter the workforce, whether you're going to be an employment lawyer or not, whatever area you're in, your clients are going to be talking about privacy. And the thing that goes along with that is I've been doing a lot of advising lately on social networking. So what about employers who go on to Facebook or things like that and learn things about you? And is it a good idea for employers before they hire you, and can they get one of their young people to sort of friend you and then go onto your Facebook page and find out what you're really like? Because you can imagine you might actually get some interesting, useful information about potential employees who might be strange or have bad habits or whatever. And so some employers are kind of curious about this and are interested in doing it. And we actually very strongly advise against it. And the reason is that when you hire people, you have to be absolutely blind to a lot of things like social preferences, personal preferences, sexual preferences, religious affiliation, and a whole cast of things that are illegal to consider when hiring. And if you go on to social networking pages, you see people, and you learn things about people, let's say their religion or their sexual preferences or whatever, that really should have no role in your decision making. And whether you consider them or not, the fact that you've accessed it and learned it and then made an adverse employment action creates a causal connection that is really problematic when someone is not hired. So we don't allow it. And for example, when I gave a talk on this recently, I gave the following example. You're about to hire a guy for a senior manager position and in New York, and one of your younger colleagues comes in and says, I know you really want to hire Joe Smith, but I have a friend who's his friend on Facebook, and he showed me a picture of Joe standing naked, I shouldn't say naked, standing in Times Square in his boxers in the middle of the day, and I just thought you should know about this. And the employer didn't want to hire him because he thought he demonstrated bad judgment. But in New York, you can't not hire someone for legal out-of-work activity that's kind of silly. You can't use that as a basis not to hire someone. It's unlawful. Now, that's why I changed my hypothetical to naked. If he was naked, they could actually, because that's public exposure, and they probably could have gotten away with not hiring him. But it's really dangerous when you get this information to take it out of your brain and not use it in the hiring process. So we advise against it. And then on the going outside, we're asked all the time, what about giving references? Because what we advise employers is that all references should be neutral. That is, if someone calls for a reference, the policy is it must go to the HR department, and we only give title, dates of employment, and with the employee's permission, compensation level. We do not give positive or negative. That's our policy, period, full stop. Very dangerous to start giving positive or negative references. And that's, if you instill that as a policy and you say that's your policy, then it's incredibly useful practical advice and a good defense when someone says, oh, I really want a reference. But what's happening is someone saying to their colleague or former manager, well, will you give me a reference on LinkedIn? And will you say something good about me? Or, God forbid, they say something bad. I have a case right now where we represent a company and an employee was let go in economic layoffs, and he was looking for a new job in the same industry, and he actually had either an offer or was on the brink of getting an offer from another really good company, and he asked his friends in the office and his supervisor, would you give me references? And they said, oh, of course we will, completely against company policy. And not his supervisor, but a work peer called the competitor and said, you'd be nuts to hire this guy. He's just really, whatever he said. It was highly negative, and the guy didn't get the job. And the company itself actually had good reviews for the man, and was going to get his supervisor, if asked, would have given him a positive reference. But as a policy, we had given him a neutral reference, and the guy didn't get the job. And he's suing this is in Massachusetts, he's suing my client for tortious interference with his prospective economic advantage. I know that sounds like a lot of words. You probably learned it in torts class, but it's a true thing. It's where someone intentionally goes out there and screws up your economic opportunities without justification. That's really what that guy did. I mean, so this one, he's a researcher, that's his title. A researcher at my client, pretty low-level guy, has now gotten the client sued in federal court in Massachusetts for doing that. But that kind of stuff happens on those social networking things all the time. Like LinkedIn, I don't know if you do LinkedIn because it's a little bit for more older people, but I knew Susie Q at such and such company, and she's the best. Often they're good, but they're not always good. And so how do you protect yourself as an employer? Well, we now have social networking policies in the handbook, which is you really can't stop people from saying, I worked with Susie and whatever. But we require people, if they're going to do it, to disclose, I'm not saying this on behalf of the company, and they have to say that. I'm not speaking for the company. And people in general, once you have that policy, follow it because they want to be helpful to their friends, but they don't want to get themselves in trouble on the job. But it's literally a new written policy in employment handbooks that I promise you 2 years ago, no one was even talking about. And it's all just, that's how sort of the workplace is so evolving and exciting because there's so many new things happening all the time, even apart from all the new laws and statutes. And then the two other ones I just wanted to mention that are kind of new and different I have to mention, and I'm going to say this without my biases showing, there's an amendment, the Franken Amendment, which was signed by the president. I don't know if anyone knows what that is. It's very new. And Franken is the former Saturday Night Live character or personality, Al Franken, who now is a senator. And I will say that when I wrote my what we call them client alerts. So when there's a new development in the law, we send it out to clients. And one of my associates I work with wrote the first draft, and I revised it. And when I revised it, I pointed out, former Saturday Night Live personality Al Franken, and the powers that be of my law firm, which are far more powerful than me, said, there's no way you're allowed to make fun of Al Franken in a firm document. But I think that was my subtle way of saying I don't think that his amendment was really sensible. It didn't make sense. But basically, I think this often happens. It was well intended. There was a terrible, terrible situation where a contractor I think it was for BlackRock, or one of these government contractors is over in the Middle East. Someone said it. Blackwater. When this woman was brutally raped, and in an employment setting, and she had signed an arbitration agreement so that which is not out of the ordinary, that all claims that arise from the workplace need to be arbitrated. And she wanted to bring basically sexual harassment claims as well as others in civil claims in federal court, and the company argued that had to be covered by the arbitration provision, which would really have limited her recovery in enormous ways. And it was such an extremely terrible situation. I haven't read the opinion, but a court concluded that she could bring her claims in court, and where they may well have properly been. But the point is that Al Franken, in response to this, got an amendment passed, the Defense Appropriations Act, that said that no government contractor who's getting a contract of over $1 million can have an arbitration provision with any employees. And if they subcontract, they also can't have an arbitration provision. So that means that the government, I don't even think this is constitutional actually, but someone brighter than me can research it. The government has gone and said existing employment agreements with employees that say you have to arbitrate your wage disputes or your employment disputes or whatever are completely wiped out if you want to have government money. And so it's pretty far-reaching, and I'm not sure he understood the practical effect of that because everyone's going to have to go back and check all their contracts. And some employees actually like to arbitrate. And so it was sort of throwing the baby out with the bathwater in the sense that they were trying to stand up for the rights of that poor victim, and in the end have sort of upset contract law all around this country. And so it'll be interesting to see how it plays out and whether there are any judicial challenges to the Franken Amendment. And wait, there was one more I wanted to tell you, and I know this was an employment class, but this is what I like to do, is talk about it. My associates, they know I love the law. And the other one I wanted to tell you about, which is really somewhat interesting, is a similar story where legislation in the employment area came from a bad experiences. I don't know how many of you know who Lilly Ledbetter is. And the Lilly Ledbetter Fair Pay Act, which is the very first piece of legislation from the president, signed. And basically what that's about is that Lilly Ledbetter worked for Goodyear Tire and Rubber for many, many years. And she, a really long time. And she found out far into her employment that really throughout the entire employment, she had been paid less than her male counterparts, which is illegal. And she sued, and she didn't sue under the Equal Pay Act, but she sued under Title VII, gender discrimination in pay. And she went in and sued, and she lost on statute of limitations. They said that your claims are too old. And she was, she lost, and actually this made it to the United States Supreme Court because they wanted to decide on the following issue, whether her cause of action arose when they first gave her bad pay or when she should have learned she could have learned that she was getting paid less than men, or is the violation of the law every time she got a paycheck that was unfair. And the law had been that more the paycheck, it's split, but the paycheck rule, that is, that causes of action would accrue. And this made it to the Supreme Court, and the Supreme Court said, oh no, that it's not every time you get a paycheck, it's when the adverse decision was made, which was outside the statute of limitations for Lilly Ledbetter. So that basically Lilly Ledbetter said, I've been paid less for 10 years, but the decision that led to that was 10 years ago, so therefore she was out of luck. She should have known, the Supreme Court said in their wisdom, that men were getting paid more, which seems, in the workplace, the chances of you really knowing what other people make are very slim. And I can tell you from personal experience, when I was a junior associate, I found out in a weird way that someone who was my year, a guy, made more than I was. And it's really quite devastating. And really, it's like so unjustified. And you're like, wow, how did that happen? And it's just it's hard to describe the emotional reaction of feeling wronged in that way. But this one was told you're out of luck. It's a statute of limitation will begin when you should have known, in a circumstance where most people just wouldn't know. So the president, very first piece of legislation, signed into law the Lilly Ledbetter Fair Pay Act. And it covers Title VII, age discrimination, disability discrimination, anything that has to do with your pay, that every time you get a paycheck, a new causes of action arises. So even if the decision was made 5 years ago that led you to be off with your male counterparts, every time you get a paycheck that reflects that decision, the cause of action starts up, and it's 2-year look back. So you can recover for the 2 prior years, not going back to 5 years. And so this was an effort to correct an injustice to Lilly Ledbetter. It's been very interesting because the statute, everybody amended their employment lawsuits immediately to add a Lilly Ledbetter claim, because you can see what it did. Anybody who had a statute of limitations defense from an employer was going to get the employee to amend to put Lilly Ledbetter in so they could go farther back in time. And the courts have been struggling with this a little bit on the statute of limitations point and have clarified that this is only about paychecks. This is only about what you pay, no other kind of discrimination. But it was an effort, and I think a fair one, to try to correct an extremely unjust situation that started with Lilly Ledbetter. I have to say that even though there's a statute named against her, Lilly Ledbetter never saw a penny. She never got $1 from the Goodyear Tire Company. She never got anything. And she, except her name on a statute, which people will know about till the day she dies, and probably till we all die if you're going to be in the employment field. Okay, well, I've just packed so much into my time. I didn't know if anybody had any questions they wanted to ask about practice of law, work-life balance, employment law. Anybody? Yes?
So it's work-life balance, raising 4 kids and making it to managing partner at an office. What tips do you have on managing raising children, and what do you think helped you along the way?
Well, first of all, 2 immediate things come to mind. First, I say this without kidding, amazing children, and just really special children, and good and loving children. And Elizabeth's dad was wonderful, and very, very involved and helpful. But to be blunt, I mean, you see, I'm in an unusual circumstance because I was pretty young when I had a lot of children. And so a lot of people my age are now still have I only have 1 child left at home. So when I was really young, I was a 5th-year associate when I had 4 children. And so I feel bad even discussing this because I feel like I made a lot of mistakes because it was so confusing, you know? But I think the key things are to try to have dinner every night, to pick 1 field trip every year for each person, and do not do any mother-facing activities at school, do only child-facing activities. Do you see what I mean, though? I mean, you get nothing out of it if you're like on the charity, auction committee. But if you do the 1 field trip a year for each person, or 1 party in each class, which is what I tried to do, I don't know if Elizabeth, if you noticed, but that's what I was trying to do. I never, you see what I mean? You have to really make your choices carefully about how you spend your time. And so those are the kind of choices I made. And the other thing, I remember this moment of epiphany so well. One Saturday, I was in our backyard pushing Chris's little brother on a swing set, It was a Saturday morning, and I was like this, I got so much to do, I got to get to the market, got the dry cleaner, somebody's got this, somebody's got that done, and I was like pushing this baby like this. Elizabeth knows him, he was the cutest, he's still adorable, but he's like this big now, but he always had a little runny nose, and he was just like in a swing set bundled up like, and I promise you, I had an epiphany, and I said, it was like, stop, you don't always have to be accomplishing something. Just push the baby. And it was I'm not kidding, that really happened, and I remember the moment so well. It was like, just push the baby. Do not plan your day, do not stress out, just push the baby. And so sometimes you don't always have to be accomplishing 20 different things. Did things fall through the cracks? Oh yeah. I mean, we didn't have like a perfectly decorated house, and I made the exact same cake every single Sunday. I had no imagination. Our meals were a little rote, but we were happy. But it was, you just have to choose. And it's constantly choosing, and there are going to be times when you realize I remember saying this for sure, I'm making someone unhappy every single moment of my life. I mean, this is where I was like in my my late 30s. I'm disappointing someone at every single moment, except for maybe when I'm sleeping. Because at every single moment, there's someone who wants more of me, or could use more of me, or need more of me. And it is a very, very overwhelming feeling to know that it's every moment of the day you're disappointing someone. And you just have to do your best, because you're going to get through it. But it's not, I wish I could tell you it was easy. It's challenging, but it's so rewarding in the end. Yes, Kate?
Have you found that technology has lightened the load a little bit because it's easier to do work from home?
Oh my gosh. So different. Now I'm thinking, when Elizabeth was young, we didn't have cell phones. I mean, I remember having to make a choice, like, I would not take a cell phone call while I was driving children or driving like my son's carpool. I would not do that. But now that there's computers and I bring my laptop home, and again, please don't comment, I'm not the most technological person. But when I figured out how you could turn on a laptop and work from home, it really did change my life, because I can sit now, like even after dinner, if the TV's on or whatever, and just go through all those emails that you can't get through, someone who sends you a note or wants to check in with you or just needs this or that, or plan for the next day. Or what I like to do, I have like for example, when I'm here today, I try not to crank my anxiety up, but I think, oh my gosh, am I a log jam? Is everybody still working and getting stuff done and pressing forward without me being there, And so you can, in the morning, before you go to, I go to Pilates. Before I go to Pilates, I can send emails to all the associates saying, don't forget this, don't forget that, da, 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 da. And when I come in, it's, they're waiting for me. And it just changes so many things to be able to use the computer from home, to have email. I mean, I don't think I got email. So I've been doing it 23 years. I'm sure I was like 12 years before there was email. I mean, and when email came, it may be more than that. It was like, what is this? And voicemail, same with voicemail, but it is so different. But I will tell you, honestly, another tip, I really believe this. I think that it's rude and not the right message to try to work in front of your children. So I really did make a point of not like trying to call voicemail in front of everybody, or now that there are cell phones, taking a conference call driving the carpool. But I remember we had this carpool and they're just little grammar school boys. So Chris would be the oldest, and they were down to first grade through 8th grade. And I was picking up carpool. It was 3:30 because I was rushing. Just that particular year, I was driving carpool on 3:30 and working full time. It was kind of crazy, but I couldn't help it. I had to take a call. So I took these children to 7-Eleven. I got them all a snack, and I said, I will get you all a snack if you're completely quiet while I take my conference call. And there were 6 little boys in the car. I was able to have a 20-minute call. They were like sucking on that sugary whatever. And I was like, yay, we did it. And they were so good. And the client on the other end paid a grotesque amount of money for that advice, and they had no idea that I was like doing it in the carpool line or whatever. That's the other thing. There's so many things you can do, and people don't really, you can get away with more. Yes. A lot of work done in inappropriate clothes. Oh, gosh. Yeah.
You mentioned you discovering that you were like paid less than a male counterpart at some point. And I was just wondering how you walk the line between being like a respectful employee and like not overblowing things, but at the same time like asserting your rights and that sort of thing.
Yeah, it's a good question, because as I was driving down here, I had blocked that out. I had forgotten. I remember this. And here's the thing. This guy started in my class. He's one of those people in my class of 12 or whatever who came from Harvard. And he was very accomplished and very, very confident. And you'll find when you start out as like a first year in a law firm, people who act really confident make people think they are competent, and they get extra points for that. And even if you're confident but you don't walk around strutting, people don't get that about you right away. And so this guy was a strutter, and we started the same, and somehow I forget how I discovered it. I mean, he was awful. He literally stole my work one time. I had like a brief out, and he told my secretary not to tell me, and he took it and like copied it. I mean, he's no longer with the firm. But he was making like, it seemed small, like $2,000 more the year than I did, and I was really, I was more like offended and shocked, like my eyes watered versus like righteous. But I got it together, and I went and talked to the head of the group, and I said, I've found this out, and it seems wrong, and I just want to understand how it was that we got out of line, because it was possible with merit compensation systems that it could happen, but I wanted to understand it, and that really what it was. They had given him a bonus when he was a first year that I hadn't gotten, but I actually didn't let it go. I said, I explained to them my rationale for why I thought that was unjust, and they corrected it. They did. I think that sometimes, and I was polite about it and just direct and unemotional when my eyes were not watering when I had the conversation, but I was direct about it because it did strike me as completely wrong. And to their credit, they corrected it. And what I find as an employment lawyer is good employers will do that because there's a lot of discrepancies in compensation out there that are completely unintended. But in fact really fall on women or minorities more, even unintended, because I do a lot of compensation analysis, statistical analysis, regression analysis, and what sometimes looks like a real disconnect in compensation actually is explained by different things. But good employers want to do it right and correct it. And so they corrected it. But I remember that feeling of unfairness very well. Yeah. Anybody else? Yeah.
Hi, thank you for coming to speak with us today.
Oh, sure.
This is kind of going off of the Shive's question earlier about balancing work-life. I guess I'm curious if you could share with us how you dealt with it in terms of asking your employers, were any special arrangements made in terms of caring for your children, and how has that changed since when you dealt with it?
Yes.
And now as someone who's part of the hiring committee, is that something that's taken into consideration?
Sure. Well, there are a couple parts to your question. For myself, I worked full time the whole time, and that was just the right thing for our family, because not everybody has options or whatever. And I worked full time, except when I had maternity leave, I took 2 extra weeks. But I look back and think I was nervous and anxious, and I should have taken more time at different times. But that was just I never asked for any accommodation. And it's silly, because if I had asked, I'm sure I would have gotten it, because among my contemporaries, there are people who went part-time, and by that, like 80% time, 70% time. In fact, there's a woman who's just a little bit older than I am, who's a stellar litigator in our group, and her children are younger than ours, but her oldest, I think, is a sophomore in college now, and then they get younger. And she went 70% time at some point, and she just stuck with it and plugged along, and the firm accommodated her. And now she's on the board of this 900-person law firm. I mean, she came back full time. So there are going to be times in your life when you kind of cut back and go back. And most law firms will accommodate that. And most law firms will accommodate even hiring people part-time unless the job won't allow it. But with technology and everything else, part-time has become a lot easier to handle. But you see more of it. People working 80%. It's still a lot of time, but it's 80%. Okay. Anybody else? Oh, okay. President?
I guess in terms of working at the law firm, what was it that helped you succeed? Like, where did you find maybe your friends or your support?
Right.
Or
That's an excellent question too, is I think the reason I've succeeded in this law firm is because someone said to me when I was a first-year associate, it was an orientation, that your clients are the partners. You have to treat the partners in this law firm who you're taking assignments from like they're the client, and just do your absolute best job for them. And really kind of, I don't mean that in an obsequious way, I mean it in they're the people to whom you're providing actually excellent work. And I really tried to do that. And I developed great relationships with partners outside the litigation group who then would call me directly for business. Like the guy I called from the hotel in London is a corporate partner. I got to know through work, not through a social, because other thing with your family, there's not a lot of social. But after, when you start out, there's a lot of socializing with other single young lawyers, and then once people have families, you just never see them again after work. But you develop professional relationships with people, all different groups. And when I came up for partner, they told me it was unprecedented. I had 47 lawyers in the firm write comments about me. That means not 47 friends, 47 people who had actually worked with me. And I hadn't set out to have such a wide net, but I really attribute the fact that I both became a partner in the litigation group and then got all those what I'd call positions, management positions for the compensation committee, and even now through the fact that a lot of people have worked with me. Now my practice area, employment, is one where people in different practice groups do call me a lot because they'll have a corporate client who needs this advice or that advice or gets sued or whatever. So I work with people professionally. But I think what I tell the people I'm working with is look for opportunities to work for people outside our practice group, because you need to develop a network through the entire firm, not just on our little corner of our floor. So, okay. Anybody else? Oh, yeah.
I know that all of the first years, at least, are going to be registering for our first, like, we can choose classes soon. And you said there wasn't an employment discrimination class when you were in law school. Was there anything particular that you thought was very valuable for litigation, or for anything that you just found especially helpful?
Yeah, there was. I'll say there was employment. I think there was an employment discrimination class then. I just didn't take it, which I'm sorry I didn't. I mean, I'd love to go to an employment discrimination class. I just think it'd be so interesting, and I do a lot of teaching, so it would be just, I think I'd learn a lot. But, you know, honestly, for litigation, to this day, I still use what I learned in civil procedure. I would totally get your civil procedure down. And, you know, civil procedure, I hope the teacher's not here, is not rocket science. I mean, the tests can be made to be hard just for fun, but the opening the rule, it's a set of rules. It's memorizing them, looking them up, and it's, I just think civil procedure is really important for people who want to do litigation, for obvious reasons. But it's amazing how useful it is, almost more than anything else that I got out of law school. I loved other classes more, but that probably has come in the most handy. And the other thing I would say to people who want to do litigation, although the environment is really competitive, if I had to do it all over again, I would have tried to have a judicial clerkship. Because what happened was when I was graduating, I felt really old. You know, I had taken years off and I needed to get to work. And, you know, I look back and think that year would have made no difference. And it's really quite an invaluable experience if you're going to do litigation, to be in a judge's chambers, either at the trial or the appellate level, just to get both a sense of how to analyze, and also to see lawyers present themselves all the time. I mean, judges I know, I love hearing that when they tell me stories about lawyers, not by name, but by behavior, who do a great job and do a bad job, and what they do that's good and what they do that's bad, because I'm always, you know, eager to try to do a better thing, and it's so interesting to hear from that perspective what works and does not work, both with the writing and the briefs, as well as with oral presentation. And so I think that to have that perspective coming out from a judicial clerkship, if you want to do litigation, would be great. And I say that knowing that I know the spots are really hard to get these days.
Outside of a clerkship, do you have any, especially since you were on the hiring committee, suggestions to people who might want to work in big law but can't get either a summer associate or a job right out of law school because of the economy?
Yeah, I think that you should, the best thing I would say now, it's a little untested, but based on my experience and sort of my long-term view of this, is that you should get a job where you develop an expertise. And not, you don't have to be the world's living expert on, you know, trust and estates or whatever, but your chance of going into a big law firm go way up if you offer something that certainly people coming out of law school don't. Or, you know, there's this whole generation of people, small generation I hope, who've been deferred and deferred and deferred their start dates, who are not going to be as fresh as you are when you get into even your first job if it's not in a big law firm. So you need to just work on, I would think, a specialty. If you could find something that you really like and become specialized in it, that would be very attractive. Because what happens at the lateral level, no one's doing much lateral associate hiring, but at the lateral partner hiring even, or when partners come in with groups, it's because they're a special area. No one's hiring anybody general in anything. They're hiring someone. And then the other thing, and I would add that you could do that and become specialized in government jobs too, state or federal. So if you worked at the SEC or something like that, where you really have something that's quite different than people who have, quote, just gone to law school, that would be a route to getting a job in a bigger law firm. And that's been true really even before this particular economy, that people who might not otherwise gone straight into a big law firm come in and are really successful because they bring with them some specialty that the people who come right out of law school, I have no specialty. I probably still don't. So that's what I would suggest. Okay, anything else? Well, this has been my pleasure. It's been really fun. And if anyone has questions afterwards, I'll be here for a few minutes, and then I'll see you soon.